The appeal of Cooper and Universal Music Australia considers when an intermediary is liable for authorising an act comprised in copyright. Although there were other appellants, this video will focus on the findings regarding Cooper, who owned and operated the website MP3s for free, and eTalk, which was the internet service provider for MP3s for free. The parties appealed against the original decision, which found that they had authorised acts comprised in copyright under Section 101, subsection 1 of the Copyright Act. The main issues of the appeal were what the proper interpretation of the term authorises in Section 101 subsection 1 was, and whether Section 112 capital E applied to the appellants. We will consider these issues in turn. Section 101 subsection 1 makes it an offence to authorise the doing of any act comprised in copyright in Australia. To determine if a person has authorised an act comprised in copyright, the court must take into consideration the matters in Section 101 subsection 1 capital A. Did the person have the power to prevent the act? The nature of relationship between the person authorising and the person doing the act, and if the person took any reasonable steps to prevent or avoid the doing of the act. In relation to Cooper, the court agreed that Cooper had the power to prevent the infringing acts because Cooper could have created the website in a way which gave him more control. The court agreed that a relationship existed between Cooper and the persons who downloaded music files and uploaded hyperlinks through MP3s for free. This was additionally proven by the fact that Cooper derived commercial benefit from these relationships. Finally, the judges decided that although Cooper did have disclaimers on the website, these were defective and not a reasonable step to prevent or avoid the infringing acts. Regarding eTalk, the court concluded that eTalk did have a power to prevent because it could have declined to provide connection services. Both judges agreed that, unlike Cooper, eTalk only had remote relationships to the people committing acts comprising copyright, but Justice Kenny did place some weight on the fact that eTalk was advertising on MP3s for free. Finally, the court recognised that, although eTalk asked Cooper to take down the website, when Cooper failed to do so, eTalk did not pursue the issue or take down the website itself, but began to advertise on the website. Therefore, no reasonable actions were taken to prevent infringements. Moving on to the second issue, the appellants attempted to rely on Section 112 capital E to show they should not be liable for authorising infringing acts. Section 112 capital E is an exception to Section 101 subsection 1, which states that a person will not be liable for the copyright infringement of others, just because the person merely facilitates the environment in which infringements occur. This is relevant to the appellants because both provided facilities that resulted in infringing acts. The court decided that Cooper had created his website in a way which invited users to do acts comprising copyright, and this invite constituted more than mere facilitation. eTalk was also deemed to be doing more than merely facilitating because it chose to derive a commercial benefit from hosting the site through advertising. Therefore, both Cooper and eTalk were unable to rely on Section 112 capital E because both had done more than merely facilitate infringement. In conclusion, the court agreed with the primary judge's decision that Cooper and eTalk authorised the copying and communication of copyright sound recordings, dismissing the appeal.